Before you file that marriage-based green card application, understand this crucial reality that could change the entire course of your immigration journey. What worked for your friend 3 years ago might not work for you today because the immigration landscape has shifted in profound and measurable ways. If you are not fully prepared for how United States Citizenship and Immigration Services is evaluating cases right now in 2026, you could be setting yourself up for significant delays, multiple requests for evidence, prolonged uncertainty, or even outright denial that forces you to restart the entire process at great emotional and financial cost. In the following discussion, we will examine exactly what is happening with marriage-based green card cases, why immigration officers are scrutinizing applications more carefully than ever before, and most importantly, the practical steps you can take to build a strong, authentic case that withstands this heightened level of review. The information shared here is drawn from current trends and processing realities, and staying with this analysis could save you months of stress and potentially thousands of dollars in complications down the road. Welcome to US Visa Info, the channel dedicated to breaking down complex immigration processes into clear, actionable guidance that reflects the realities of today, rather than outdated advice circulating on internet forums or anecdotes from years past. We focus on what actually matters in the current environment based on observed trends in adjudication, policy shifts, and the day-to-day realities faced by applicants. Whether you are a United States citizen or lawful permanent resident sponsoring your spouse, or you are the beneficiary spouse seeking to understand every aspect of the process, this comprehensive overview is designed for you. We will cover the fundamentals of marriage-based green cards, the interview process, common pitfalls that even sincere couples encounter, and the specific strategies required to assemble documentation that genuinely demonstrates the authenticity of your relationship in a way that satisfies the expectations of reviewing officers. Understanding the marriage-based green card process begins with recognizing precisely what you are applying for and the level of examination it will receive. When a United States citizen or green card holder sponsors a foreign spouse for permanent residence, they are entering one of the most closely scrutinized immigration pathways available under current law. This level of attention is not rooted in any blanket skepticism toward love or marriage itself, but rather in the persistent historical problem of marriage fraud that has compelled the agency to implement stronger verification measures to protect the integrity of the system. As a direct consequence, even the most legitimate couples now navigate additional layers of review that were less common in previous years. The foundational step in this process involves filing Form I-130, the Petition for Alien Relative, which formally establishes the qualifying family relationship between the sponsoring United States citizen or lawful permanent resident and the foreign spouse. For spouses who are already physically present in the United States and eligible to adjust status, this petition is typically filed together with Form I-485, the application to register permanent residence or adjust status. These two forms work in tandem to transition the applicant from whatever temporary or undocumented status they currently hold into lawful permanent resident status, provided all eligibility criteria are met. In contrast, when the foreign spouse resides outside the United States, the process shifts to consular processing, where the approved I-130 petition is forwarded to the National Visa Center for further handling, including the collection of additional documentation, fees, and the eventual scheduling of an immigrant visa interview at a United States embassy or consulate in the beneficiary's home country. Both pathways demand extensive supporting materials, including thorough background checks, mandatory medical examinations, and, in nearly all marriage-based cases today, an in-person interview. A critical distinction that many applicants overlook concerns the type of green card ultimately issued, which hinges directly on the length of the marriage at the moment of approval. If the marriage is less than 2 years old when the green card is granted, the beneficiary receives a conditional permanent resident card valid for only 2 years. Before that conditional card expires, the couple must jointly file Form I-751, the petition to remove conditions on residence, submitting fresh evidence of the ongoing bona fide nature of the marriage, along with its own set of fees, and, frequently, another interview. Failing to file this petition on time or submitting inadequate documentation can result in the loss of lawful status and the initiation of removal proceedings, a situation that carries serious long-term consequences. On the other hand, if the marriage has already lasted more than 2 years at the time of approval, the beneficiary typically receives the full 10-year permanent resident card immediately, bypassing the conditional period entirely. This distinction explains why some couples strategically time their filing to approach or surpass the 2-year mark when feasible, although practical considerations, such as the need for work authorization or unrestricted travel, often make waiting unrealistic. The intensified scrutiny applied to marriage green card applications today stems from several converging factors that have reshaped enforcement priorities. Immigration authorities have refined their focus on fraud detection. Advanced technological tools now allow deeper cross-referencing of data sources, and several high-profile cases of fraudulent marriages have prompted broader policy adjustments that affect all applicants regardless of their sincerity. Officers now routinely access sophisticated databases capable of cross-checking social media activity, international travel records, previous immigration interactions, and even patterns in financial transactions. They are specifically trained to detect indicators suggesting that a marriage may have been formed primarily to secure immigration benefits rather than to establish a genuine ongoing marital union. In practical terms, this means that presenting a valid marriage certificate alone is no longer sufficient to meet the threshold of proof. Reviewing officers expect to see concrete evidence of a shared life that extends well beyond the wedding ceremony itself. They look for financial interdependence, demonstrated through joint bank accounts, reflecting regular deposits, withdrawals, and shared expenses by both spouses. They examine shared housing arrangements evidenced by lease agreements, mortgage documents, or utility bills listing both names. Jointly filed tax returns, beneficiary designations on life insurance policies and retirement accounts, mail addressed to both partners at the same residence, and photographs documenting the relationship over an extended period rather than isolated events all form part of the expected portfolio. This body of documentation serves a deliberate purpose. It constructs a coherent timeline, illustrating that the relationship developed organically and that the couple is actively building a life together in the manner typical of married partners. Officers recognize that no two marriages are identical and that individual circumstances vary widely. Some couples prefer to maintain separate bank accounts for personal or cultural reasons, while others may live apart temporarily because of work obligations, military service, or family responsibilities. The essential requirement is not conformity to a rigid template, but rather the provision of clear, logical explanations supported by documentation that aligns with the couple's unique situation. The interview has emerged as the central arena where this heightened scrutiny is applied. In earlier periods, a substantial portion of well-documented marriage cases were approved without any interview based solely on the strength of the initial submission. That approach has become exceedingly rare under current policy. United States Citizenship and Immigration Services now mandates interviews for the vast majority of marriage-based applications, whether processed through adjustment of status within the United States or through consular processing abroad. These interviews fulfill several critical functions. They enable the officer to evaluate the credibility of the couple, identify any inconsistencies between statements and submitted materials, and determine whether the spouses truly know each other in the intimate, everyday manner expected of a married couple. Standard marriage interviews involve both spouses appearing together and responding to a broad range of questions covering how they met, the details of their wedding, their daily routines, family relationships, financial arrangements, and future plans. Officers carefully observe body language, the natural comfort level between the partners, and the degree to which their answers align not only with each other, but also with the documentary evidence previously provided. Questions may begin with general inquiries, such as the circumstances of their first meeting and progress to highly specific details, including the color of bedroom curtains, who typically handles grocery shopping, or what was prepared for dinner on a recent weekday. The intent behind these precise questions is never to trap applicants or test rote memorization of trivial facts. Rather, it is to discern whether responses stem from genuine shared experiences or from rehearsed coordination. Couples who genuinely cohabit and share daily life are usually able to answer such questions fluidly, even when small discrepancies arise on minor points. Paradoxically, minor inconsistencies on insignificant matters can sometimes reinforce perceptions of authenticity, whereas perfectly synchronized, identical answers from both spouses can appear overly scripted and therefore suspicious. In certain cases where initial concerns are raised, officers may conduct what is known as a Stokes interview, a procedure derived from established federal court precedent. During a Stokes interview, the spouses are separated and questioned individually, after which they are reunited to reconcile any identified discrepancies. This more intensive format is typically reserved for applications where specific red flags have surfaced, although it remains within the officer's discretion to apply it to any case. Selection for a Stokes interview signals that the application is receiving elevated attention, yet it does not automatically equate to denial. A significant number of Stokes interviews ultimately result in approval once the spouses successfully demonstrate the bona fide nature of their marriage through consistent, credible testimony. The process of removing conditions via Form I-751 essentially requires the couple to prove the ongoing validity of their marriage once again, this time with emphasis on how the relationship has continued to develop and deepen throughout the conditional period. Processing times for I-751 petitions have lengthened considerably, frequently exceeding 1 year, and interviews that were once uncommon are now standard in many offices. Officers evaluating these petitions assess whether the marriage has followed typical patterns of growth, including sustained financial interdependence, continued cohabitation, shared significant life events, such as the birth of children, ongoing family integration, and evidence of long-range planning as a unified couple. If the marriage dissolves during the conditional period, the removal of conditions becomes more intricate but remains achievable in many instances. The beneficiary may file Form I-751 independently by requesting a divorce waiver, provided they can establish that the marriage was originally entered in good faith. This requires presenting the divorce decree, a detailed personal statement describing the marriage and its dissolution, supporting documentation from the period of the marriage, and, when appropriate, affidavits from friends or family members who observed the relationship. In situations involving abuse or extreme hardship, protections under the Violence Against Women Act, provisions that apply regardless of gender, allow the victimized spouse to file independently without the cooperation of the abusive partner. Evidence of the abuse, which may include police reports, restraining orders, medical records, or witness statements, must be submitted to support the waiver request. The specific pathway used to enter the United States carries substantial implications for the marriage-based green card application. Fiancé visas, commonly referred to as K-1 visas, impose their own layer of scrutiny. These visas require the couple to marry within 90 days of the foreign fiancé's arrival in the United States, after which the adjustment of status process begins. Officers closely examine the timeline of the relationship. When a couple asserts a long-term partnership, yet pursued the K-1 route only recently, questions naturally arise about the reasons for the delay or any recent changes in circumstances. Similarly, a marriage that occurs immediately upon the fiancé's arrival but is supported by limited pre-existing evidence of the relationship may prompt officers to inquire whether the union was accelerated primarily for immigration purposes. Entering the United States on a tourist visa or under the visa waiver program and subsequently marrying a United States citizen does not automatically disqualify an applicant, but it does raise potential issues related to intent at the time of entry. If reviewing officers conclude that the foreign national entered with a preconceived plan to marry and remain permanently while misrepresenting the purpose of the visit, this can constitute visa fraud with serious repercussions. The distinction rests on timing and surrounding circumstances. An unanticipated romance that develops after lawful entry on a non-immigrant basis is generally viewed favorably, whereas evidence that the individual arrived already engaged or intending to marry and immigrate immediately can trigger a finding of preconceived immigrant intent. The 90-day rule offers a helpful guideline in this context. United States Citizenship and Immigration Services may presume misrepresentation if conduct inconsistent with the original non-immigrant purpose, such as marrying and filing for adjustment, occurs within 90 days of entry. While waiting beyond the 90-day period does not guarantee approval, it substantially reduces the presumption of improper intent. Consular processing, while avoiding some of these intent-related complications, introduces its own challenges. The foreign spouse remains abroad during what can be a lengthy adjudication period, unable to work in the United States or reside with the sponsoring spouse, and any prior unlawful presence in the United States may activate re-entry bars upon departure for the consular interview. Unlawful presence exceeding 180 days, but less than 1 year, triggers a 3-year bar, while 1 year or more of unlawful presence activates a 10-year bar. Waivers for these bars are available, but require a showing that the United States citizen spouse would suffer extreme hardship far beyond the ordinary difficulties of separation if the waiver is denied. Such waivers demand extensive additional documentation, extend the overall timeline by many months, and are not assured of approval. The most effective strategy for navigating these requirements is to begin accumulating documentation early in the relationship, well before any immigration filing is contemplated. Couples who have naturally built a shared life over time accumulate the very evidence that immigration authorities seek: joint utility bills arising from cohabitation, joint bank accounts reflecting merged financial management, photographs capturing ordinary moments across months and years, and jointly filed tax returns once eligibility arises. These materials exist organically as byproducts of married life rather than as artificial constructs created solely for the application. Difficulties frequently arise when couples marry quickly, maintain largely separate lives due to external factors, or delay consideration of documentation until the filing deadline approaches. In such scenarios, the sudden effort to generate evidence can appear contrived precisely because it is generated for the purpose of the petition rather than reflecting an established, shared existence. Initiating these practices early, opening joint financial accounts when expenses are combined, adding a spouse to a lease upon moving in together, updating insurance and retirement beneficiaries following the marriage, and systematically preserving records of shared travel, holidays, and major decisions creates a robust, credible record that aligns with the expectations of reviewing officers. Honesty remains the cornerstone of any successful application. Every form completed, every response provided during an interview, and every document submitted must be truthful and accurate in every respect. Past immigration violations, criminal history, or other complicating factors should be disclosed proactively because the agency maintains comprehensive databases that are likely to uncover such information independently. When issues are disclosed voluntarily, they can often be explained or mitigated through appropriate supporting materials. When the same issues are discovered later, they are frequently interpreted as attempts to conceal material facts, severely undermining the applicant's credibility. Effective interview preparation centers on refreshing genuine recollection of the relationship rather than attempting to memorize scripted answers. Couples should sit together and review the full chronology: how they met, the progression of their courtship, the proposal, the wedding, shared living arrangements, division of household responsibilities, family interactions, and long-term plans. These are details that authentic couples know intimately, yet the pressure of an interview setting can cause momentary lapses. Familiarizing oneself with the actual shared history promotes confident, natural responses. Memorizing anticipated answers is counterproductive because it produces a rehearsed tone that officers are trained to detect, and any unanticipated question can leave the applicant struggling. Instead, comfort with the real narrative allows flexible, honest replies to whatever is asked. It is equally important to revisit the submitted application and supporting documents so that responses remain consistent with what was previously stated months earlier. Even minor memory lapses that create apparent inconsistencies can generate unnecessary concern. Financial sponsorship requirements represent another significant hurdle that many couples underestimate. the sponsoring United States citizen or lawful permanent resident must submit Form I-864, Affidavit of Support, demonstrating income or assets sufficient to support the immigrant spouse at 125% of the applicable federal poverty guideline for the household size. For a two-person household in recent guidelines, this typically translates to an annual income of approximately $22,000, with higher thresholds when dependents are involved. When the sponsor's individual income falls short, several remedies are available. The use of assets that generally must equal 5 times the shortfall amount, inclusion of the immigrant spouse's continuing income, where applicable, or the addition of a joint sponsor who meets the income criteria and assumes the financial obligation. Early awareness of these thresholds prevents last-minute complications when the affidavit is prepared. Even in genuinely bona fide cases, certain recurring mistakes continue to create unnecessary obstacles. Submitting minimal documentation under the assumption that the sincerity of the relationship is self-evident frequently results in requests for evidence and extended processing times. Inconsistent interview responses caused by inadequate review of the filed application or insufficient discussion between spouses can generate doubt. Continued separate living arrangements after marriage, without a clear documented explanation such as work-related assignments or family emergencies, often raise suspicion. Overlooking or miscalculating income requirements on the affidavit of support leads to delays or denials. Ceasing to collect joint evidence after receiving conditional approval leaves the couple unprepared when the time arrives to file Form Y-751. Perhaps the most fundamental error is the belief that love alone suffices as proof. While love is deeply personal and internal, the immigration process is fundamentally bureaucratic and evidence-based. Officers cannot assess emotions; they evaluate the objective record presented. When submitted materials fail to reflect the true nature of the relationship, approval becomes unlikely regardless of the underlying sincerity of the parties involved. Avoiding these pitfalls does not demand perfection. It requires informed awareness of agency expectations and consistent effort to meet them throughout the entire process. Same-sex marriages are afforded identical treatment to opposite-sex marriages under prevailing United States immigration law, following landmark Supreme Court decisions that extended full federal recognition to such unions. Same-sex couples complete the same forms, satisfy the same evidentiary standards, and undergo equivalent levels of review. Cross-cultural marriages, whether same-sex or opposite-sex, may prompt additional questions aimed at understanding how the couple navigates cultural differences, how families have responded, how holidays and traditions are observed, and how communication occurs across differing norms. These inquiries are not indicative of bias. They represent verification that the relationship has been authentically constructed across those differences, rather than formed for convenience. International relationships, particularly those that began online or involved partners residing in separate countries, require clear demonstration of the relationship's development despite physical distance. This includes travel records documenting visits, evidence of sustained communication through messages, calls, or video, financial transfers between partners, familiarity with each other's social circles and families, and concrete plans for future cohabitation. Throughout every stage, the timeline of the relationship is evaluated holistically, rather than at a single point. Officers consider the full history from initial meeting through the present, including any periods of separation, financial challenges, or other complexities. Attempting to conceal gaps or difficulties creates greater problems than addressing them transparently with supporting context. Patience is essential because processing times remain lengthy and variable. Adjustment of status cases currently range from 10 months to more than 2 years, depending on the specific field office, while consular processing can span 8 to 18 months or longer. Form I-751 adjudications often require 1 to 2 years. These estimates fluctuate with agency workload, funding levels, policy adjustments, and geographic location. While awaiting decisions, couples should continue building and preserving evidence of their shared life. Filing joint taxes, maintaining joint accounts, cohabiting where possible, and documenting ongoing integration. Officers reviewing an interview conducted many months after filing, will inquire about developments during the intervening period. Any cessation of joint activity requires a credible explanation. Marriage-based immigration continues to represent one of the most frequently used and ultimately successful routes to lawful permanent residence in the United States. Hundreds of thousands of sincere couples complete the process successfully each year. The distinction between a straightforward approval and a protracted, stressful experience almost always reduces to the quality of preparation, the consistency of documentation accumulated over time, and a clear understanding of current adjudication standards. Approaching the application as a serious legal matter rather than routine paperwork, allowing evidence to develop naturally instead of manufacturing it at the 11th hour, maintaining complete honesty about all circumstances, and remaining current with evolving trends, rather than relying on anecdotal success stories from previous years, collectively and substantially increase the likelihood of a favorable outcome. Immigration law and policy are not static. They evolve in response to legislative changes, court rulings, and administrative priorities. What proved sufficient last year may require additional support today. Relying on reliable, up-to-date sources keeps applicants aligned with the prevailing environment. If this detailed examination has provided clarity on the marriage-based green card process and the preparations necessary in today's immigration climate, consider subscribing to US Visa Info. Activate notifications so that future updates on United States citizenship and immigration services policy modifications, current processing times, real applicant interview experiences, emerging request for evidence patterns, and step-by-step guides for every phase of the immigration journey reach you promptly. Share this information with friends, family members, or acquaintances who are either beginning their marriage-based green card journey or navigating it and feeling overwhelmed. The more individuals understand the actual requirements, the better equipped they become to assemble compelling cases that result in approval. Questions and experiences shared in the comments are read and often shape future discussions that benefit the broader community. Being well-informed and thoroughly prepared today safeguards your future and positions you for the strongest possible outcome in this important process. We look forward to addressing another vital immigration topic in the next update. Until then, remain informed, stay prepared, and approach each step with the diligence the process demands.